Hi everyone, welcome back to The Whole Truth. I'm your attorney, Gil Arbel, and today I want to explain where the Tyler Robinson case actually stands, not from a political perspective, but from a criminal defense attorney's perspective. There's been a tremendous amount of speculation online, but courtrooms operate under very different rules than social media. So as we all know, Tyler Robinson has been charged in connection with the assassination of Charlie Kirk. And where we are in the litigation is we are about to get to the preliminary hearing. So recently, one of the prosecutors was found to be held in contempt by the judge for violating a court's gag order, making public comments about the case. However, the defense, as a result of that, made a motion for sanctions against the prosecution, and specifically the sanction that they were seeking was removal of the death penalty from the sentence possibilities. However, the defense lost that argument. So what that means only is that the death sentence is still in play. Doesn't mean that there's any more likelihood that the death sentence will be ordered, even if he's found guilty, than there was previously. It just means that that sanction was not deemed appropriate for the violation or the contempt by the prosecution. Now, on July 6th, the preliminary hearing is going to be held. Now, what a preliminary hearing is this is not anything like, it's like a trial, but really the burden of proof is very low for the prosecution. It just means that there's probable cause. Usually, as a criminal defense attorney, a lot of times, all this means is that the person that is in the courtroom being charged is in fact the person named in the indictment or the complaint. That pretty much overcomes the necessary burden for prosecution. Unless there's a very strong defense, again, namely they have the wrong person here, or there's very strong evidence that can be presented of self-defense or an alibi, the defense is not likely to win at the preliminary hearing stage. A lot of times what the defense uses the stage for is merely to maybe create some chances for impeachment, which means diverging statements that can be used to attack someone's credibility at trial, but really as like a chance to present the whole defense. It's not really that type of proceeding. Now, one of the aspects that's been in the news is that the defense lost the right to subpoena Tyler Robinson's boyfriend, I forget the name off the top of my head, for the preliminary hearing. And that just means that the judge is saying there's nothing that the defense offered that could be elicited from testimony by Tyler Robinson's boyfriend that would be relevant into whether or not there's probable cause. Remember, preliminary hearings is basically just if there's probable cause to continue with the trial. And so the judge just held that the defense didn't present enough sufficient evidence that the boyfriend would say or could say anything that would eliminate probable cause. And so that's all that ruling meant. Now, what you should expect at the public is the first substantial public presentation of the prosecutor's evidence. It'll be likely to provide the clearest picture of how prosecutors intend to prove the case, and also maybe some of the defense's major arguments what they're likely to be going forward. So as a criminal attorney, that's what I'll be watching for. Not because this hearing decision is going to really decide the case, but because it's going to provide a window into how it's going to look going forward. no matter how emotionally charged a case is, and this one is definitely emotionally charged for a number of reasons, our legal system is designed to separate public opinion from admissible evidence. That's why criminal cases are decided in courtrooms, not on X, not YouTube, and not by stupid conspiracy theorists online. So that's the whole truth.